or the resolution, either?
I think there were two
Okay.
primary differences from what we recommended. One is that the legislature decided to put a 5-year limitation period, which I was.
We had a very tight vote on that.
It was a tight vote here, as in our work group, so it's certainly an issue on which reasonable minds.
Yeah, okay.
The other issue that did not go through all the way is that we have recommended an office with 2 people. One person who would be in charge of identification, the other person who would be in charge of training. And I think mostly due to the bean counters, the budget area, they decided to make that a 1-person office, and that would be just the person in charge of training, and that they would outsource the investigation to various law firms. There is a provision in the bill that says that they will reevaluate that in a couple of years. I'm curious to see what happens with that. My guess is that they will find they are spending more on law firms than it would cost them to have another personnel. But they wanted to see how that actually played out, which is not unreasonable either. So I would say in primary substance, it is what we recommend.
Great. Well, congratulations. I have to say, when Senator Courtney invited me in to the meeting to lay out the proposal for this, it was breathtaking. Not only the scope of the timeline that they want the report and recommendations done in January, by the end of the year. I think this was in February when we had the conversation, just as we were in the transition, and honestly, I said, of course, sure, we'll do our best, but trying to buy ourselves a few contingencies and ways out if we needed. Vicki, I just want to thank you again publicly for taking this on, and your courage to take it on, but also the adept handling of high-flying work group and a huge issue with a lot of public interest and input in the process. It was unique, I think, in terms of our work group processes, just because of the extent of public input. The comment that you get, the online portal that the public had for comments, and we were able to accommodate those. So again, just strong thanks and accommodation to you for that. Is there anything else left for the commission to do? Are they done with us? And because that was the other piece, that there might be things that they would ask us to do in a follow-up session, but it sounds like enough got done in the report and the recommendations adopted that we should have done.
I'm not aware of anything at this point.
Okay. Great. Any questions for PK? Good. Yeah, well, I think that is a signature product of the law commission, I think, and you're right, one that was different in many ways from a lot of what we do. So it speaks well, I think, of our adaptability to take on something out of the box like that. All right, something more in the box, probate. Man, that's classic. That is classic law commission work. But we are, I think, also done. 3 bills this session in broad terms. One, as you know, was the amendment principally of the small estate process. Thanks to Susan as the reporter on that. To me, I think probably the piece of that is going to be most well received by the bar and most useful is the provision for calling in the assistance of the court to enforce the directive that the parties turn over assets to the claiming successor, so that when that bank tells the affiant or affiant, never did get resolved, or counsel when they approach them for a transfer of funds from an account in a small state, when you tell you no, the letter is testamentary, you say no, you don't. We have a statute that authorizes, in fact, directs you to turn this over, because I have the authority to collect it. Now we have the ability to put them on notice and demand, and if they fail to turn over within 30 days, then we have the opportunity for enforcement by the court with an attorney fee award, and I think that's probably going to mean that they will get those accounts turned over and make the small estate a more viable process for administering an estate. There was an amendment, a couple of amendments. One of the most significant amendments from the Bankers Association, I think it was a good one, is that now on the front page, because of this provision that allows for demand and the prospect of attorney fees if assets are not turned over, now on the front page of, I say now, it'll be effective as of January 1st, on the first page of a small estate affidavit will be a notice in 14-point type in caps, as I recall, calling the attention to any third party that this is a document that does require attention, and I think even the ones that the attorney, I think it might be on the warning in front. So it looks like a document that somebody needs to pay attention to. And I think the banks wanted that just so that their members didn't expose themselves to liability by not getting the point. This means what it says. So that to me, I think was Susan, do you remember anything else in the small estate arena that is the most significant? I think we cleaned up some timelines and some just messiness. Yeah, it's the kind of thing when you get a room full of lawyers who all of their careers have done small estate, and you open the statute and you actually walk through the statute. I think everyone realizes that there is just a lot that's done, even with the statutes, there's a lot that's done just by mythology and herd mentality and tradition, and we learn a lot. And I hope we've cleaned up some of those things by a clearer path to the process.
And a little more, the other thing I think may be helpful is a little more direction in the
Yes.
small estate itself to the Athenian who's working without a lawyer, which is most of them.
Right.
To say, yes, you are a fiduciary, you have to do certain things, and it's just an attempt to get the message a little more clearly out.
Yeah, good point. There are things in the petition that are designed to call out to the applicant that they do have these obligations. Of course, the courts have been 90, how many % of small estates really are done just by pro se with no lawyers involved, and these people just do not know what they're getting into. So we tried to beef up some of the information in the affidavit to call their attention to their responsibilities. Those of us who do small estate proceedings will want to make sure we update our forms for January 1st, because they will be significant. Not significant, there are significant differences. They're not significantly different, but there are differences that are among that notice about others. So take a look at that and make sure we update our forms. Another bill that I think will be really well received by the bar is the no asset probate case, when you're filing a probate just for the purpose of exercising a power of appointment, for instance, whatever the case may be. We learned that there are courts who really did hold the lawyers to, and because the statute said, publication requirements, bond requirements were necessary, accounting requirements, all of these things, even in the no asset estate. And so we've really slimmed down what has to be done in the no asset estate, including, and this one also amends regular probates, but now we have the opportunity, even in a regular probate, for a statement in lieu of an annual accounting. We've always had that in a final accounting, but now if you have an estate either no asset or you can do this in an asset estate as well, with the right process, we can do a statement in lieu of an annual accounting, which will save a lot of money in estates that are moving smoothly and don't have the need to do the kind of accounting that's required for an annual accounting. So great work. It's the kind of stuff that the commission does, I think, quietly, but will have a big impact on practice law, and really should reduce time, costs, and complications to lawyers and clients in a number of states. And the last one was the wrongful death statute, wrongful death bill. It's a species of a no asset estate because the wrongful death claim is not an asset of probate estate. Of course, that has to be prosecuted by a personal representative. So again, it provides guidance for how we move through a probate estate where the only asset is a wrongful death proceeding. We do clarify the requirements of court approval of the settlement, both in a wrongful death and in a personal injury action. Again, had great help from the bar that handles a lot of wrongful death proceedings. We thought we could do some things, but we heard from the Trial Lawyers Association for the we weren't going to get away with. So we receded from some of those just to avoid the battle, Trial Lawyers Association from committee, but still some great work. So those, I think, are kind of the bread and butter of commission projects.
Lane, did you want to just briefly address the small error that's found in 307?
Yeah, it's a little thing. We'll do it.
We'll do it on the bill. Just an FYI.
Yeah, what was it? It was, what was it? It was, see, it was so small. I
It's
forgot
very
now.
small. It's in section 30, I mean, it's in section 32, and it's, the language is the decedent's will.
Oh, yeah, it was, oh, thank you, Warren. It was a Warren Darris cleanup of the harmless error statute. So it wasn't even one that we had done this time. Warren perceived something, recommended it, we looked at it, looked like the right thing to do, so we endorsed it. It inadvertently created a place where wills appear to be subject to a process in two different parts of the statute. It's not going to create any real issues, but we do need to clean it up.
The bottom line is what what we're talking about doing is if one of the commission's meeting prior to the short session, we'll bring a bill that specifically fixes that.
And I would put an emergency clause on it, so we don't have to wait because ideally then this bill becomes effective in January. We'll have a fix in the short session with an emergency clause that fixes it within probably 6 weeks. So by mid-February, ideally we'd have that fixed, and the number of states that it would affect will even be that much smaller. So, yeah.
But just an FYI, at one of our meetings, we're just gonna have to technically approve that, and I'll work with Risa and Susan.
It's an easy fix, we just undo what we did.
Yeah.
That's what you get for trying to be accommodating. But yeah, I know it's our fault not to really think deeper about what the effect of that was. So yeah, the BK, we'll want to make sure that gets done on, and with an emergency clause and that's, and for those of us who've been around, we know that we've done that before. We've always created some issues as you solve 20, you create a new one, then you have to come back sometime and fix that. We've done it before, we'll do it again. It's a process, that's why we keep meeting.
Yeah. Lane, just one question of a trivia nature. Was this the longest standing work group in the history of the Law Commission?
No, the longest standing work group had to have been the, elected chair.
Well, it depends on how you count that.
Well, yeah, that was a work group that Bernie Bale chaired. I think was that it was one of our very first Law Commission meetings. You came wanting to modify the elected chair statute, so we created a work group that somehow morphed into, we almost after a few years of working on that, we almost became a community property state, I think. And then back away from that, I'll bet that one was at least 2 years.
Okay.
Not constant work, but.
But involved, but there was a version of a work group even before the commission.
Yeah,
It was, that started and then, it became clear that it was commission help.
Yeah, we helped, it took us a while, that got complicated, but we did fine, it ended up with like a mini, like a fair statute, like a share statute. The other one that took longer was the brave walk through the juvenile law.
Right.
That Kate Brown chaired for years and years and years. That was just every, I think you could, like painting the Golden Gate Bridge. As soon as they got done, they could have gone right back and started all over again. That just seems to be a perpetual.
There are definitely more documents related to that project than anything else we have so far.
Yeah.
I was just curious, because that project went for 6 years.
6 years?
That's probably
longer than that. Wow. Really? All right, and Sandy, so that takes care of the recap for the session. We do talk about, well, let's go ahead and move number 7 up as long as it's a session item and talk about budget.
Yeah, it's a brief update that I checked in. So in the end, for those who aren't familiar with the way our budget of the Oregon Law Commission is used by the state, we are embedded in a kind of obscure part of OJD budget. I don't know when that decision was made to put us, I mean, we are related to, I guess you could argue we're related to that budget, though.
We're nomads, we have been in all parts of the budget.
So, for good and for bad, I think the bad part this year is that there was a directive, as those of you who've been through the legislative process know, some documents that come out look really good for us, and a couple of them, it looks like you're gonna get a big raise, in terms of both of our percentage raise and in our overall money, and the one, policy option, package we asked for, which PK alluded to, which was significantly raised. That actually would have almost doubled our budget. And we have a very small budget, in general. But, the section that you were in, the pass-through section, the OJD budget, they kind of cut across the board. It ended up being 3% of the money that was originally given to us. So our total, requisition for the next biennium is $320,442. That basically covers my salary. We do have, administrative assistant back in Eugene who is working on various projects, for us. We don't have a full-time, it's someone who actually just retired from the law school, Debbie, who I know who's been wonderful and is going to help us quite a bit moving forward. Our hope is to have that be a more permanent, position at the UO Law School. With this funding, I was checking with Erica Daly, who's the financial person at the UO Law School, who kind of takes the money and then figures out the best way to use it. We're going to be fine for the next biennium. She's not concerned about any of our ability to operate or to pay my salary or to pay the assistant. There's not going to be much room to grow with this. It's going to be the biggest hurdle, interestingly, in having our position move to UO, or in my position specifically as director, is that as a public institution, we have tremendous costs related to PERS and other related healthcare, all sorts of related things which are associated with being a public agency. So it does, in the long term, we're going to need to be, I wouldn't say more aggressive with our budget request, but just help the OJD or whatever department we end up getting thrown into understand that we do need incremental raises just to ensure that we can have a full-time director. Again, for this biennium, my conversation with Erica, she's not concerned. We did have quite a bit of savings in the last biennium because for part of the time, the commission didn't have any full-time employees. Right. So we're fine for now. In 2 years, we can kind of have those conversations and see what's going on. But that's where we stand. At the end, we did, Lane wrote a letter, and PK wrote a very strong letter, which we really appreciated, kind of asking for that staff attorney, because for those of you who, I think everyone understands, but we did have a staff attorney for that project, and it made all a world of difference. And I think that for us to have the impact that I think we've shown we can have, having a staff attorney in place would be a really phenomenal goal. I think the goal is certainly have that in the policy options package the next time the budgets come up and see what we can do.
Well, the work on the next budget starts tomorrow, so truly that's the case. Although when I was in the legislature, I actually opted out of PERS. Can't you do that?
You can.
I'm kidding.
There's arguments for it, arguments. No, I don't think it's actually calculated that way for our position. Talk to you. It's actually the biggest part of the UO budget crisis right now. It's not just PERS, it's actually everything on top of the salary. To hire a full-time position, and those of you who work for the state, I'm sure understand this, you're paying almost as much as the salary, and in fact, some get more than the salary, on top of that, the requisition.
All right, well, like I said, I mean, I'll be glad to help. The work on the next budget starts tomorrow.
Yeah, so the good news is, for the next biennium, for our operations, and even to run significantly more workers. The good news is, my position doesn't cost a whole lot of money overall. I mean, for the commission, I think it's good. It's a fair, rate, but also we don't have a huge amount of expenses. Luckily, we are in legislature. We always are able to have space for free there. Willam's been extremely gracious. We continue to allow us to use this space when needed. Several law firms in the Portland area have provided space. The Bar Association has go space. So we do save a lot of money due to those types of donations. So I have no concerns about our operation.
All right, any questions for Sandy? All right, let's talk about the status of ongoing projects.
Yeah, a couple, we have 2 ongoing projects with work groups. Several other projects here that have been approved, and we made the decision not to move forward to start work during the session.
Sure.
The session was busy. Wanted to make sure we got our priorities passed. And I have questions about a couple of them, but we can go through the active work groups right now. Yeah. We can start with LLC. John DiLorenzo, do you want to get
Sure. Sure, and Sandy, feel free to augment anything I have to say. First, I wanted to say, fellow commissioners, how much I regret not being there today to celebrate Lane's tenure as our chair. Lane, I mean, you and the Law Commission have been synonymous in my mind for so many years, and I just want to take a moment to thank you for your dedication and all your hard work. It really has been a labor of love for you, and we are much further along than we ever could have been without your participation. So thanks a lot for your leadership. I really, really appreciate it. Secondly, we have had 3 meetings of our group. During the first meeting, which Lane attended, I was afraid that the group might be so ambitious as to maybe challenge the time that the elective share and juvenile work groups took. You know, there was the possibility that this could devolve into a Dickens Bleak House project. But I think since then, they've trimmed their sails fairly significantly. We've had 3 meetings. We've got about a dozen members. Excellent representation, I think, among business firms, not only in Portland, but in other parts of the state too. So I really believe it is an inclusive group. I should mention that Valerie Sasaki she's with the Samuels firm. She's doing a super job helping us, and she's sort of fulfilling a vice chair role for the work groups, and she and I are getting along quite well. Sandy, of course, has added a lot to the overall proceedings and has, made available all the resources we have requested and has helped guide us through our discussions. So the group has pretty much decided to limit itself to the Uniform LLC Act. There is not that much disagreement so far on major policy issues, unlike that which we encountered in the adoption group. It's functioning more as an editing group, which is great. The group is really focusing on details. I'm learning a great deal, and in order to encourage participation, because it's going to be a long haul, we have persuaded the Oregon State Bar to provide all the lawyers who are participating CLE credits for at least the portion of the time that they invest in the project. So that's helping to attract people to the meetings too. The group right now, we have discussed sort of a fork in the road, and we've taken one direction. I need to have a pretty thorough discussion, though, before we get too much farther along with Dexter Johnson and the Legislative Council group. And here's the issue that we're going to confront. It is the desire of the group to begin with the Uniform Act and then augment the act with Oregon-specific rules. Rules that are necessary, departures for Oregon, and also rules that reflect some of the policies that have been established by recent legislatures in the area of transparency and that sort of thing. If we do that, though, and that's our preferred course, we will have a product that is one package. But to do it in the form of a bill, we are going to have to repeal a significant number of existing statutes and then on a wholesale basis replace those with this new product, which is the Uniform Act with Oregon-specific provisions. Legislative Council normally resists, gigantic gut and stuff exercises. and normally prefers to amend each and every existing statute, as necessary. The problem is if we do that, if we take that approach, not only will it double the amount of time that we have to invest in the project, but it will lead to a fairly ununderstandable product, because you're going to look at it and you're going to see 1,000,001 amendments to existing statutes, and it is going to be very difficult to read it holistically. And so my assignment is to, as soon as some of Dexter's existing workload subsides, to sit down and talk with him and see whether he would be willing to approach the drafting that way. Now, that has happened before for Oregon Law Commission projects, but it's, Legislative Council doesn't really favor that approach. But I think in this case, we'll be able to make a pretty good case as to why we should do it. Otherwise, it'll be very difficult to understand, very difficult to explain. On the other hand, if it's holistic, we can say this begins with the Uniform Act, and then we can comment on the departures from the Uniform Act. So that's what we have in mind right now. Anyway, we've had 3 meetings and things have been going along pretty well.
I think that's a great policy reason to approach the drafting that way. We do have precedent, so it shouldn't, I hope it's not a heavy lift.
Just one update from this morning. This group did meet this morning, and Sean Brennan from Legislative Council was able to call in. He's not the decision maker of whether that would be allowed, but he was not wholly opposed to the concept. So I think he's going to be our contact and was going to be doing the drafting with us for those bills. So I think that was a positive step in the right direction this morning.
Because otherwise, you're right. You present a bill and no one's going to know what it means, because it's just going to be these disassociated amendments to statutes that don't really tell the whole story.
And my only thing is, John, do you have anything else to add?
Pardon me?
Do you have anything else to add?
No, that's it. That's my task. And I think what we'll do is, Sandy, maybe we'll include you in the conversation when we put that together, and also include the LC staffer that's been assigned to us too. But I think this is a decision that Dexter's going to need to make.
The good news about that group, again, updating this morning, is I think the biggest issue I see is that if we really are aiming at 21, it's a lot of work. This group, I will say, is willing to do it. They are taking a tremendous amount of time, and what we were working on a bit this morning was trying to streamline the approach a little bit to make sure that, and we literally were only able to get through like 4 sections today of one article, just going through different policy concepts, because there are a lot of, the biggest difference, I think the biggest lift on this is not that there is any opposition to the uniform law. In fact, as John said, the goal is to fully incorporate the uniform law, but there are a tremendous amount of policy decisions that are currently present in the Oregon statute. And I think what this group wants to make sure that we're doing is discuss those discrepancies and ensure that we don't miss anything. So it's a good process. I felt really, really good about the discussions that are going on. After sitting through the probate group and having that be my first introduction into this type of work with the commission, I'm not concerned we won't be finished by 21, but I think it's going to be close.
Mark, did you want to ask about charging orders?
Can I jump in?
Yes, sure.
John, Keith Stepanovich, is there representation of criminal prosecutors? And the reason I ask, and this goes back unfortunately about 10 years or so when I was at Department of Justice, there was an effort to modernize the LLC Act then. And one of the primary concerns that I heard was that our act allowed corporations to exist as shell corporations so that money could be laundered, drugs could be sold, things like that. I know nothing about the criminal law field, but clearly somebody does and had great concern about lack of transparency in incorporators. So is there somebody that is at least looking at that perspective, John?
Yeah.
Yeah, we are. We don't have a prosecutor on board, but the Uniform Act does not favor transparency. The Uniform Act favors efficiency, but I mentioned that we were going to have Oregon departures that were going to be plugged into the Uniform Act. And one of the departures is going to be reflected in the policy we see that recent legislatures have made towards wanting more transparency so the public knows who's standing behind LLCs. And so I believe that our product will reflect those sensitivities.
Did you say it's DOJ on the group?
Well, Attorney General's office.
Yeah.
And John, this is new,
Yeah.
this is the first meeting, where she attended, but Kate Dennison, from the Attorney General's office has agreed to join the group.
Oh, great.
Yeah, Secretary of State, is.
They're on it.
That's what I thought, yeah, so there's where the coverage is gonna be.
Yeah, we have both of the agencies that have agreed to join the group, and Secretary of State's been the last couple meetings, Attorney General joined this morning.
Who's from Secretary of State?
So we did have, Peter, but
Yeah.
Peter actually just got a new job.
Oh, no.
So we now have,
Okay.
we now have Jeannie Webb, who's actually also representing Secretary of State, on our other work group, which Mark will.
Okay, all right. You satisfied?
John, this is Mark Comstock. Would
Hi,
you
Mark.
make a note to fix or at least address the charging order anomaly in the statute? Justice Walters gave an extensive opinion about shall we say, the flaws in charging orders in not only LLCs, but in various other types of entities, and it would be helpful to have something that is at least workable now.
Didn't she, in that opinion, though, reference the Uniform Act as a I think a favorable reference to the Uniform Act?
Yeah, she did.
Yeah.
She did.
She's commissioned.
We will duly note that. Thank you.
All right, good. Anything else on the LLC Act? Great project. All right, Mark, tell us how notaries are doing.
Well, this is, Lynn and I jokingly referred to this as a one meeting complete work group. No, not really true. This is remote electronic notarization. And first we had to kind of wrap our minds around what is out there and what it really meant, and what the aspects of what happens if you have a document notarized by, let's just say a call center down in Plano, Texas, and how does the Secretary of State have jurisdiction over something like that, and how is it saved? That was the first thing. There are two major vendors in this arena, and we've had presentations from both of them to actually see how these things work.
They're literally flying up here for the meeting from Michigan and Arizona, so it's been very helpful.
Must be good business.
Well, it's there, and we've also had in this work group very diverse participation, because the reporter from the Uniform Act has regularly attended and answered lots of questions. So it's been very helpful in that. And we have thought about and discussed the policy ramifications of evidentiary issues, because these remote notarizations, they actually have a video and audio record of what occurs, and that is saved somewhere. We wrestled with that a little bit, and the subpoena power of state courts about how they can actually get something out of wherever it might be kept. So it is an improvement, policy improvement, and we will have a recommended bill. There are two model acts that are kind of competing out there in the big wide world, and this is, I think it's in 13 or 14 states right now.
It's fully passed, there's processes going on in almost half the states now.
So we've kind of identified what would be preferred in in Oregon, because we have had uniform acts, and there was a bill not brought forth by the commission that was, I think, the credit unions for electronic notarization. And there's also some activity about electronic recording, which is kind of a predicate for all of this. So we'll have a bill that I think we'll have a draft probably in September and ready to rock and roll and
Well, as a footnote, I don't know if it's come up in your discussion, but speaking of recording, there is the uniform, help me out, do you remember it? Huh? It's uniform real estate, it's a recording act.
It's discussed, yeah.
Yeah. A lot of states have adopted it. I remember trotting it out to the county clerks probably about 10 years ago, and I think the response was kind of like the way most people feel like when they first hear about electronic wills and remote notarization, just, it sounds like maybe the world is moving forward faster than that, and maybe if we're looking at recording, there is a uniform icon that's been adopted in most of the states.
And one other thing, we're trying to solve some of the political resistance that we anticipate. So we've got estate planners that are on this work group that are, in fact, they see real value, especially in the elder abuse situation about you actually have a record of competency.
Isn't that interesting? That, you know, the concern that you have coming into this is this going to be rife with fraud and abuse, and just like what Susan said about electronic wills. If you do it right, and you set up the protocols and the statute right, you'll have better protection.
Yeah, and that's what we're finding.
You know, and we've seen that, as Mark mentioned, we've seen two presentations to see different vendors, and the fact that there is an audio video recording of the entire process that is going to exist, and we're going to work on where it's stored to make sure that that's accessible and safe, but that is a huge improvement.
Yeah.
Secretary of State is certainly involved.
Right.
We're trying to figure out if we're going to have a dog and pony show to go to some selected probate judges that we want to diffuse concerns that way.
Yeah, that's being discussed.
Yeah, it's being discussed. And we anticipate it's going to go forward and be something that can be pretty successful.
Yeah. Not going to get the front pages of the papers, but it's
No.
going to affect how lawyers and well, everybody.
This may end up being one of the more utilized projects from the law commission, because I think it's going to, just watching the presentations the last time, I think this is going to fundamentally change, especially in real estate. And that is the way it's been used over and over again, because if you bought a house and having to show up with, you can do the whole thing, notary pieces of it through this in probably 5 minutes, to be honest. It's a really,
Cool.
Yeah, anyway.
All right, great.
So a couple updates, and I have some questions for commissioners about some of the other projects that have been passed. I am about to go out on parental leave, or we're expecting about 10 days, our second one. So very excited about that.
Congratulations.
Thank you. And we're set up with the active work group there, but when I return, and the idea would be in September, October, I'll be fully ready to get at least 1 or 2 more groups started. We have 3 that have been approved. The one of them, hearsay, Keith and I have a plan where we're actually now recruiting students when they come back to do some research. So actually, I'll skip ahead to hearsay because that's a project that I think could become a really exciting project, but it is an extremely diverse idea, and it's one that when Keith and I spoke about it, we want to make sure that we understand what the status is of those laws around the country, what work is actually being done in that area. So it's kind of an ideal project for a law clerk, and the idea is to have the University of Oregon Law Commission fellows. We're actually recruiting starting this summer, so hopefully have 2 or 3. We do have actually some funding to at least fund their research hours, which is nice to start. And the idea is to have something available, hopefully sometime next year, to give us a basis for that group. So that's where we stand on that group. Keith, does that sound about right?
Correct. Yeah, the reality is that the waterfront's extremely broad, and we have no clue whether any work has really been done in any other states. So we might as well get that homework done ahead of time, so that when we come back to the commission, we can define what the question is.
Yeah, right.
We can then get the answer.
So, skipping back ahead to, direct criminal appeals, which there was one project before. I have, my one, part of the reason I didn't start it before was because we were busy with the session. The other is, I don't have a solid list. I have a list of who's participated in the past, but I'm working, and I do need some help from folks on this one, of who would be the right people to work on these projects moving forward. Judge Bouchon, were you on this project?
Yeah, I chaired it.
Yeah.
Are you planning on continuing to chair the project?
Well, that was a discussion
Yeah.
I wanted to have.
Okay.
This next piece, it's kind of a misnomer because it's not really direct criminal appeals. We've already solved that problem. This is dealing with appeals from municipal court,
Right.
which was too big of a piece to try to tackle last time. And we didn't have the right players.
Right.
That was the real problem. And so we need to create a different work group for this project. And I'm not sure that I'm the right person to chair this work group. I'm willing to try to do that,
Well,
although
the appeals do come to circuit court.
they do.
Although not in Multnomah County.
Not in Multnomah
Yeah,
County,
that's right.
we don't have, we are the municipal court.
Yeah.
So that's, we don't see these things.
Yeah.
It's kind of foreign to us. The other thing, two things that have changed since the last work group. One is now I have additional responsibilities as the presiding judge in Multnomah County, which is very time challenging. And Jim Nass, who did the bulk of the work in the main work group, has retired. But I do have at least a couple of ideas for people.
And I have
who
a
might
couple
work on
names
this.
who had responded to me probably 6-7 months ago at this point. It's only a couple. So I guess my ask would be, I'm ready to set this group up starting in the fall. I just need help with names. I'll go through the process of inviting them and setting out the proposals and getting space and all those things. Just making sure that there is at least one member. Usually, Blake, I just want to check with you. Do we always want at least one member of the commission on all of our work groups?
Yes.
Okay. So ensuring that we do have a
You
member
should
of
have
the
a
commission.
commission chair.
Yes, exactly. That's the goal. So
Yeah.
having a chair, and then as many names and as many constituencies as we need to have a successful group. I think the best time to start that is going to be, if we could have a couple meetings before the Christmas holiday, that would be a solid goal with this group.
Well, it seems to me the constituencies is a fairly narrow group, I think, in this
Yeah.
case. I think you should have someone from the circuit court, at least on the work group, and maybe outside Multnomah County where they actually do get
Right.
these things. And apart from that, I would think, some city or, attorneys, because these are coming from municipal courts. So the League of Oregon Cities has the City Attorney Association, that can recommend members. And probably some criminal defense attorneys who would have experience in filing these appeals. And I would expect that probably the lawyers or two that you might find from the City Attorney Association would know who the defense lawyers who are prosecuting these things, prosecuting these bills.
I don't know if Carl Myers is still
Good thought.
representing as
Municipal judge.
Municipal Judges Association.
Yeah.
He would be a resource with broad
Excellent.
knowledge.
Carl Myers, he's in Kaiser,
Okay.
he's a Kaiser municipal judge, or
Something like
he
that.
was forever, and does represent the Municipal Judges Association in the legislature. So, well, he'd be probably a great resource for other work group members.
Maybe Janice Zironoff
Yeah.
from Woodburn.
Uh-huh.
She's been a long time municipal judge, I guess.
Yeah. I think that's a good point. I think Carl especially would be a great, font for, other work group members. But I would get back above the, Oregon cities for some city attorney names as well.
So I guess I'll work on getting people there. Just want to make sure from the commission, if Judge Bouchon is unable to do it based on her schedule, which I have a lot of respect for, are there any other commissioners who would be willing to work with this project? Okay.
Excellent. Great.
Thank you, Judge Bouchon.
Okay.
If you need an additional person, join us.
Oh, sure.
that'd be great.
Yeah.
Yeah, I really wanted you both to be able to join the project.
Excellent. All right. Oh.
And I'll provide all the logistics. It's really just, coming to meetings and making sure that you run the meetings, but all the logistics, all the background stuff, I'll take care of. So I try to.
And unlike uniform law committee acts, these you'll be starting with the statutes.
Yeah,
And
exactly.
just amending them to do what everybody's doing without the statutes.
Or do it better.
Oh, yeah, right.
Do-
Yeah.
There's a lot that's unclear.
Absolutely.
with these
It's a
statutes.
terrible set of statutes.
Yeah.
So thank you both. I'll be in touch with both of you probably next week, just certain logistics stuff. We're not gonna meet right away, but, I'll start working on recruiting, members, and thank you.
Another name for you to check is Mark Peterson.
Okay.
He's one of our referees, but he was a former municipal judge, and he is, I believe, still active in the Municipal Judges Association, and is very knowledgeable about this stuff, so.
Great. I mean, you guys have a good work group.
Yeah.
Yeah. All right.
I look forward to it. And then the last one is collaborative law, which has been sitting out there for a while as well. And what I have there is I have a proposal. I have a work group that has a bunch of names that are ready to go, but I don't have the commission member on that group to volunteer to chair it. So it's another one I'm asking for, potentially, because that one, we have some strict, and this one could be very similar to the model we've been using with the LLC group, where we have some very passionate attorneys who are ready to go on this group, and actually have come up with a really solid list of names to start with. I have a couple of UO professors who are interested in it. So it could be, the model we're using with the LLC group, which John talked about, is we have kind of a vice chair model, where John is running the meetings, but a lot of the substantive discussion is being run by Valerie. We have that in place for this group. So if there is a commissioner who would want to come in as a chair, I think this is another one where we could start on that timeline sometime late 2019, early 2020.
Can you give a brief thumbnail of actually that?
So this is my very limited area of expertise, but my understanding, speaking to a couple of faculty members and otherwise, is this is a process that is generally used in divorce cases. And it is quite controversial amongst the bar, and that's why, for a lot of reasons, and that's why this is one that's going to be interesting.
Well, because the bar has come around.
No, they have.
accepted that this, kind of like what
The bar-
Will,
I would say,
this is where the world is going.
I wouldn't go so far as to say they're accepting of it.
I would say the bar
agree with the idea, but the question is it the practice of law?
Yes.
Right.
Should there be a special certification?
Yes, and what changes do they need to make in the rules of professional responsibility in order to accommodate it? So, yeah.
the thumbnail is that attorneys on both sides agree to engage in, I guess, the form of mediation, except the biggest.
Alternative,
Yeah, it's an ADR concept, but the biggest difference is that they agree that if the mediation fails, that neither party, that's my understanding, will then represent,
Neither lawyer will.
neither lawyer will then represent the sides afterwards. Because the idea is that as much information is being disclosed in good faith as possible during that process, and really locks the attorneys down to that agreement. And that is the piece. There's a lot of belief in it in the alternative dispute resolution world, but I know there is a lot of concern from, not our bar association, I agree they've come by, but I think there will certainly be individual family attorneys who will have concerns. And then also just attorneys who just like you said, about having a statute in any way dictate the practice of law.
This is it's a uniform act, we have enactments, there are enactments around the country, and we have lawyers in Oregon doing it.
We do, yeah.
And on,
Yeah, well, is that right? I did not know that.
and that's one of the issues.
Oh.
Who gets to do it?
Oh, it's interesting.
Because it's collaborative.
Yeah.
Yes.
You can mediate without.
Well, I understand that, but in the act, it's lawyers though, isn't it?
It is lawyers, and that's why, and that's what
Okay, we need
from,
this law so we can.
and that's what
corral
distinguishes
this,
it specifically
well,
from other forms of alternative dispute resolution in family law. That these are lawyers who are making these agreements, and it's, that they're guiding their clients with disclosure of information, with the goal to operate within this practice, but with kind of that, I don't know, carrot, it's really the stick that get this done, or you can't use a lawyer. It's kind of the idea, I think. I've had some feedback from folks. I talked to Leslie Harris, University of Oregon School of Law, family attorney, family professor. Is not a fan of this because she actually believes that it would only be, but I think actually her view is a good one because she thinks that it sets up only for folks who are wealthy. But those are the conversations we could have in this group.
Well, you get a passionate group in the bar that are absolutely for it. And it sounds like, again, maybe another reason to address it is that it's happening.
It is definitely.
And so if ever to establish parameters and rules,
Part of that is fixing the ethics code
yeah,
to address it somehow.
yeah. But that was where the bar finally came out. They spent some time and have expressed a willingness to review the rules of professional responsibility so that we're not amending the rules in this bill, but that with this bill, they would agree to consider then amending the rules to coordinate with the bill. Yeah, okay, so exciting project. Who's not here?
Exactly what I was thinking.
Well,
Judge Egan's not here, no.
yeah, right, I didn't judge you. You get the chair.
The folks who are here are generally other than Susan, are academic folks who I think have teaching responsibilities. And
Well, I would say send out an email,
Okay.
probably when this is done, and tell them we need someone to step up
Okay.
and chair. It will be a great project, and you do have a uniform act to begin with, so it's not just kind of writing on a blank piece of paper, how do we do this? At least you've got a model to start with. All right.
So those are the ongoing projects, and I think it sets up for exciting next year.
Yeah, great.
And again, we're always open to new projects as well.
Yeah, well, we'll get one or two from the, meeting up in Anchorage next week.
So just Mal, E-Will.
Emails, yeah, that's all right.
Right after proposal,
We'll be
we'll
the
bring it.
first on the block to adopt electronic votes. Actually, Florida has them, there's a couple statutes, there's a couple states.
Indiana, Florida just got it, Nevada.
Okay, well, actually, that's good because
But
you
not our-
always want to be the
not our
first to
version.
adopt.
Well, these are all,
Non-uniform.
they're non-uniform and they're all coming out of the, providers. So
Okay,
these are all bills based
Yeah,
on providers that have been messed around with
yeah,
in different ways. But yeah, nobody based on everybody's waiting until we get this done.
yeah, okay, great, fun. Okay, let's get to number 5, as you all know from my email a couple of months ago or more, I've decided that after 21 years, I probably put in enough time. I have had conversations, as I also disclosed, with Keith and with PK, Keith being willing to continue to serve as vice chair, and for PK, just to prove the adage that no good deed goes unpunished, has really been gracious to express her willingness to serve as chair of the commission if she is so nominated and elected. I think it sounds like a great team, because of the experience she got in the crucible of the workplace harassment was just perfect training, and when she handled that, I think will serve us well, frankly, although this is not the reason by any means, but the commission has been managed by an old white guy for a long time, and probably some gender diversity leadership is a good thing. And not from their extensive qualifications on top of that. I guess, and then the PK, this is kind of fun because we operate under Mason's manual, which basically allows the chair to do almost anything. And you don't need seconds.
That's right.
And so, I guess I would ask, is there a motion to, elect, let's just go with that, no, are there any other nominations? Let me just ask, does anybody else want to be nominated or to nominate anybody else? Okay, hearing that. Is there a motion to elect PK as chair and Keith as vice chair going forward for the commission?
I'll make one.
Such a motion. Don't require seconds under Mason's manual. All I would ask is that first any discussion. Hearing the discussion, is there any objection? Hearing no objection, the motion carries. And that will be effective, I'll declare at the end of this meeting. I'll finish this one. Thank you so much. And Keith.
Huge shoot.
You're gonna be just fine. And I think the commission is too, I feel really good about that. That takes us down to future meeting planning.
Yeah, and I want to bring this up because.
Oh,
we
I'm
just-
sorry, wait,
Oh,
discussion of potential new members.
Oh, yeah.
Yeah.
So here's our task. With Lane leaving his seat, this opens up a position, but it's a very specific position because it has to be a member, my understanding is that to be a member or former member of the
I
Oregon.
don't think so, just has to be appointed by the speaker.
You're, okay. I have to check the rules again, but you're probably right.
What's the statute? Really?
Well,
Maybe I've been unqualified. Well, you're a former member. Oh, yeah, is it,
Hey,
Jennifer Winnie?
Lane, Mr.
Yeah.
Chairman, this is Di Lorenzo, because like you, I am a holdover member who was appointed by the Senate President. Thereafter, the statute changed that required future holders of my seat to be an actual member of the Senate. And I think you were appointed by the Speaker. And when the statute changed, future holders of your seat have to be a member of the House. That's my recollection, and maybe Sandy can double check that. But I think we were the last holdover members.
Yeah, you are so right.
when I did my check, I checked.
173.315, 2A and B, the Senate President and Speaker, appointing a member who is who is a current or former member of the Senate, and then C and D is a current or former member of the House.
So we need a House member or a former House member.
Yep.
I've had some informal discussions with folks in the Bar Association who have some ideas, but no one has been necessarily approached. I mean, before we made that decision, I certainly wanted to, if you all have any ideas.
Well, all I would say on that is I would strongly recommend a current member.
Yeah.
To have a champion in the building is just invaluable. If there is somebody who is a member who's willing to do it and willing to be active and to be a vocal supporter of the Board of Commission, that'll help us in enactments and also budget. Judge?
I would also suggest that it be a lawyer.
Yes.
I have a name in mind, but it's a current member, soon to be a former member.
No.
Jennifer Williamson.
She is a
She's
member.
actually already.
She's a member.
Yes.
Oh. A non-participating member.
Yeah, that's right.
She hasn't been to any.
She's called into a couple meetings.
Yeah.
She has called it. Okay,
Yeah.
never mind.
Yeah, no.
So she can't be another member.
No, that's right.
Well,
She is a member.
can we clone her?
I'd also like to suggest, maybe for this appointment, maybe for future appointments, that our commission could give some additional diversity.
Yeah,
And so I would like to
absolutely.
see some non-white faces, potentially, who represent different kinds of backgrounds.
I agree. So, of course, it is ultimately the speaker's,
Yep.
appointment, but, you do well to be in touch with the speaker. My guess is that with Jennifer moving on, she'll probably come off the commission.
I was
So we might have two.
wondering that too.
Yeah, we might have two House seats.
Yeah.
And we are uniquely constrained by the fact that it has to be someone who either is currently sitting or.
Is her seat also has to be a
Yes,
House
yeah,
member?
both do, that's right.
And we have, John is in one of the Senate seats, Senator Brzezinski is in the other Senate.
Right.
Well, yeah, that's right.
Right, there's not that many
And I had my informal discussion, I talked with, Shannon Newell from the Judiciary Committee, and I talked with Bar, again, it's exactly that, Keith. If there are very few members of the House who are term.
Brent Barton was one who was very interested in being appointed to the commission when he was in the legislature. You may still be. So, yeah, I'll brainstorm some.
Yeah, for me, name,
Yeah.
just curious, just wanna put that out there, because we are, those spots, at least that one is going to be available, and wanna make sure we have.
Okay, and I'll put that out to our commissioners on the phone as well, to be thinking about members or former members, and they may have the time, or one of each, current and former, if we've got two places to fill. So, okay, I will brainstorm that as well, let's get those names to Sandy soon.
we have been, talking about this for a while, but I think we are finally looking at hopefully having the elusive, commission meeting at the University of Oregon. And we're looking at the fall. We have a couple dates, which I'll send out, and it's spring, one date is in, we're gonna send out one as a possibility in September and one in October. And I'll send it out to the group to see who might be available. What UO would like to do, just to make sure that the faculty can be better engaged in understanding the commission exists and knowing what they do, is for those who are, who would be willing to come down to Eugene on a Thursday evening for a reception, the commission would then pay to stay over and pay for a meal if that's something you'd be interested in, and then we would hold a commission meeting on Friday morning. That's a discussed idea. We do have the funds for that. It's something that Erica from the University of Oregon is very in favor of. We want to get as many faculty as we can, try to get senior university administration if they to show up, because it's something that University of Oregon did step forward to support. The law school is firmly in support of, but we want to get a time, especially of, even though we don't cost a lot of money to the university, in a time of budget cuts, and especially the law school has been a huge target of budget cuts, actually, and especially amongst the faculty at the university, to make sure that folks in Eugene and at UO specifically know that we have a commission and that we're doing very well. So I will send those dates out soon to try to hopefully get some of those on your calendar. And so that's what we're leaning for the next commission meeting to take place either in September or October.
You got a cool meeting room.
We do, yeah.
Fourth floor, the conference room there.
And it will give you the best view of the the complete reconstruction of Hayward Field.
Can you still see the track from?
Well, there is no track right now.
Well,
literally.
Yeah.
But there will be. The building that is, I'll put this, the building that is being constructed is like nothing else that's ever been built in the United States. So you all will see what they're building. It is unbelievable. They're hosting the 2021 World Championships coming up. I mean, there's a tower that is going to be the tallest building in Eugene. It's part of the building. Anyway.
Why did they need that?
No, this is being completely 100% funded by,
Well, so they don't need.
by one person.
He just wants something tall.
He does.
All right. You just, I will say just, I know I had prepared remarks, but for finishing 21 years here, been a remarkable time on the commission. I want to thank you all for your work and your support over the years, you as well as longtime members and members who aren't with us anymore. I sit up here and I remember Hardy Myers, my wingman for many, many years, who was out here. Hardy was one of the original members of the commission, and in fact, probably about a week before he died, just before Hardy went on his cruise, if you recall, Hardy was ill, but they planned this cruise, and they went on a cruise down to Mexico, I think, and it was on their return, I think, in Los Angeles, where he finally I don't remember if he's come in Los Angeles or whether they got him home, but just that was the end. But I do remember talking to Hardy just the night before he left for the cruise, and just how important he thought the commission was to law and public policy in Oregon. And I talk about a champion. That guy really believed in the law commission. And it made me believe. I tend to get sometimes down in the weeds and worry about the next book group meeting and getting this bill through the process or that budget. But Hardy always had such a great overarching vision of the law commission, and seeing it as having a very significant role in law and policy in Oregon. One of the things he impressed on me in that very last time, I remember we were talking about, we were in the process of transitioning from Willamette. And one of the proposals, or at least we've been invited to the legislature, was that council could staff us, or judiciary committee could staff us, and we would just be sort of wrapped into the arms of the legislature. And it was tempting to me. Hardy thought absolutely nothing to do with that. The commission is independent, it needs to remain independent of the legislature, and to become absorbed into the legislature, which is the depth of the law commission, you need to stay independent. And so I took that to heart, and I just impressed that on those of you who are continuing, but who didn't remain independent. I would say always, too, it's hard to be in the legislative process without getting caught up in politics, but we have to avoid that. A friend of mine on the Uniform Law Commission is former chair of the former Connecticut Law Commission, which, became the, favorite group of, I don't know which party it was that was in control, but it became just an arm of the party in control, where they got some of their harder things done through the imprimatur of this commission. And understanding that, it's hard to believe in Oregon, but, I don't think there is a permanent majority in politics. And when that majority, when the majority swung in Connecticut, why the commission was the first thing to be asked, because they were identified as being nothing more than an arm of, one party in the legislature. And, I'll just offer a couple of, stories of for PK and then for the future, ways that we avoid that. I remember when the revenue committee chairs asked us to take on the right of the inheritance tax. It was inheritance tax, now of course it's estate tax for forward. That was a very challenging area because we're in one of the few states in the country. Washington and Oregon are the only two western states that even have an estate tax, and there has been a lot of effort to, at least there were in those days, to just repeal the estate tax outright. And I was very concerned that by taking on a project that attaches to the estate tax, that we could become embroiled in that debate and become victims of it, very political. And so my conversation with the chairs before we took the project on was that I was willing to take this and do it gladly on the proviso that they would not ask us whether there should or shouldn't be a estate tax. That if they wanted to have or not have the estate tax, that's not a legal question, or a technical question, that's a political question, and a revenue question. But if you want us to, if you're committed to retaining the estate tax, if you want us to create a process that is rational and will work, then we would do that. And they agreed to that, and that became part of their charging letter to us. And I don't know how many times during the course of that project I was able to hold that up and remind members of the work group. We're not here to discuss whether we should have an estate tax, but in fact, that we've got one. Ways to avoid the political, and this session, BKN did that marvelously well, managing those tricky waters with the rescue. It came out of a partisan issue, but you showed just perfect instincts in managing that through the committee. Come on, unanimously out of the committee. Yeah, there you go. So I think that, again, the independence of the commission, I think, is critical to its effectiveness in the future. I think the dogged, nonpartisan, and apolitical work of the commission is as much as we can manage. And I think the future is well settled, part of the landscape. Just wish, damn it, we would pay us what we are worth. That'll be an ongoing thing. Fighting that for 21 years, we've never gotten as much as we want. So keep that battle up, and we'll do well. Thanks. All right.
I just wanted to say that the Law Commission's reputation in the legal and political communities of Oregon is remarkably stellar.
It is.
And it is that in large part because of the work of Hardy Myers and Lane Shetterly.
And
So I want to thank you for your service to the people of Oregon.
You're here.
And let me just say, there's one other piece of the MO that I agree with you, that has, I think, established the reputation of the commission, and that is the breadth of our work groups. And I think it's so important, and BK knows this from the work we did setting up the workplace harassment group, and it's every one of our work groups. Far better to have everybody at the table than to design the perfect vehicle in the vacuum of outer space, only to have it crash and, burn as it comes to the atmosphere of political realities. But to have those voices at the table and deal with them in the work group, because if you don't deal with them in the work group, you're going to deal with it in front of the committee, and the last thing the committee wants is for any group, the law commission, to come and say, here's our product, you figure it out. We want those things figured out down to the very extent possible. And generally we do. There have been a few exceptions in the history of the commission. most part, it's having these things. All right, well, thank everybody, we are done, it's 5 o'clock.
Yeah, we don't have any
I would have a drink.
Yeah, we don't have any reservations because that was much more complicated than I ever would have thought, but,
We don't have the budget for it.
they all wanted money, but, I know that Da Vinci's, the place that Wayne suggested, they do open for happy hour, they did like 25 minutes ago. So, everyone's welcome to, join.
If anyone wants to, I'll be over there, yeah, and otherwise, I've told PK and Sadie, I, do not intend to walk away, I think, sort of like the lawyer for the Oregon Synod, the ELC, and the Evangelical Church of America. And what I learned from that is, when you call a new pastor, you bring a new pastor into the community, or a new rabbi into the temple, it's best for the old pastor to find another church. Or the rabbi to find another temple while the new pastor or rabbi gets their feet under the ground. So that's why I am stepping away, but it has absolutely, obviously, has no disaffection. I have strong affection for the commission. So to the extent that I can be of use to you and available, I will be. I don't hesitate to call. Yeah. Yeah. Give me about 6 months to catch my breath, and I know I'd be happy to. Yeah. So with that, folks, I will adjourn the commission for the last time and turn the gavel over to PK and Keith as vice chair. I have high confidence in the future of the commission. Thanks. Adjourn. I'll see you Friday. Are you going to come to me?